Hi everybody. In this video, we will discuss about consideration and the legality of object. What is consideration? Consideration is something in the contract in which both the parties give something and get something to give something to each other and get something from each other. Legal definition: when at the desire of the promiser, the promisee, or any other person has done something or abstained from doing something, or promises to do or abstains from doing something, or such an act or promise is called consideration for the promise. Like in our example, you had asked your friend that you want to sell your property and if he is interested in buying. Now, your friend will have to pay the price, that is doing something, and you will have to give your property to your friend. So it is give and take, and it is in the contract, it is consideration, and there is promise on the side of both the parties. Rules governing consideration: simple contracts must be supported by consideration. Without contracts, there is no consideration. Of course, there are some exceptions which we will come to it. Consideration must move at the desire of the promiser. That is, you have asked to for the sale of property to your friend. So the consideration must move at your desire, whatever the amount and whichever form you have asked, he is supposed to pay in that form. Consideration may move from promisee or any other person. So your friend has taken the property. Either he may pay for the property, or his dad may pay, his brother may pay. So it may move from the promisee, that is your friend, or any other person. Consideration must have some value. That is, it may be in the rupee term, which has value, or maybe the goods, or maybe another property in exchange. But something invaluable cannot be called as consideration. Maybe something trash, that is not consideration. Consideration can be past, present, or future. It may be past if you are recognizing the services performed by somebody. You say that I'll pay you so much for your services. So it is the past consideration. Present, somebody is providing you service, you are paying for it. And future, like maybe your mate may take the advance, 6 months advance when she needs because the child is hospitalized, or maybe she needs to pay for the house or something. So that is for the future. She'll be working in future, but she has taken money now. Consideration need not be adequate, but it must be sufficient. Like your 1 crore property, you may sell it for 80 lakhs to your friend. You don't mind losing 20 lakhs, but you may not give it for 10 lakhs. If that is there, then there is doubt of undue influence, which we will be doing in the future videos. And the last, it must be legal. It should not be illegal. Need not ask you should not ask your friend to do something that is illegal. And the next thing we have in this chapter is stranger to contract and stranger to consideration. Who is a stranger to contract? A stranger to a contract is one who is not a party to the contract. The rule is that consideration may move from promisee to any other person. Implies that consideration can be given by the third party as well. As long as there is consideration, it is enough. It is immaterial who has supplied consideration. So the third party who supplies consideration is stranger to consideration, that is fine in law. Then there is privity of contract. The doctrine of privity means that the person who is not a party to the contract, that is a third party, can neither sue nor be sued in the contract. Now, the rule is to prevent the burden of contract to be imposed on third party. And that is the reason the stranger to consideration must be distinguished from a stranger to a contract. For example, A is indebted to B. A has taken some debt to B. Now, what A does is he sells his property to C. And the condition is that he should pay the debt to B. Now, if C fails to pay his promise, that is, he doesn't pay to B, B has no right to sue C because C is the stranger to the contract. B can sue A actually because he has paid to A but not to C because C is the stranger to contract between A and B. There are certain exceptions to the privity of contract like trust or charge. When somebody has got the trust or charge of somebody else's property, then they are not a stranger to a contract. Assignment. If some policy or some document is assigned to some third party, then he is not a stranger to contract. Uh, like most of the time, LIC policy, if the person is unable to pay the premium, he is in need of money, may assign the policy to somebody else. Now, the person who has got this assignment is not a third party. Even though he is actually a third party, he has supplied consideration and now he is considered as the party to the contract. Marriage settlements for Hindu undivided family, the woman at the time of marriage can sue in case she has any dispute for the marriage settlement. Family settlement, if some of the members of the family divide the family property, those who are not the party to the contract, those members of the family who are not the party of the contract, can sue those who have entered into the contract. Then agency. Agent works for the principal. And the contract, for the contracts which agent enters, principal is held liable. The agent enters into contract with the third parties and principal is nowhere in between. That is, the agent may enter into the contract with the public, but the public can sue the principal. Principal here is a third party. Acknowledgement of liability. Sometimes somebody may acknowledge the liability, like I'll take the responsibility of the payment from so and so person. Like normally in the loan, the surety will take the responsibility or the guarantor will take the responsibility. Then he will be held liable, even though he is third party to the contract. Certain agreements are valid without consideration, like when they are out of natural love and affection, but they are made in writing and registered. They are made out of natural love and affection, So if one brother gives up in writing that I'll pay all the debts of my younger brother, then the elder brother will be held liable to pay the debts. Sometimes somebody promises to pay the time barred debt. Debt is always time barred, there is law of limitation, and after that time period, the debt instrument doesn't have any validity. But after that, also, the debtor promises that I'll pay it, then he is bound to pay. A completed gift. Gift is completed when the person to whom it is being given accepts it. And in gift, all of you know, there is no consideration, and that's why it is called as gift. Agency also can be there without consideration, like a son may be an agent of the father in the business. Son may not be paid anything. Guarantee. In a contract of guarantee, there is no consideration. Like if somebody is taking loan, the bank may ask for the guarantee. The guarantor doesn't ask for the payment for signing as a guarantee. That there are certain circumstances under which object of consideration is considered to be unlawful. One is it is immoral if the object of consideration is opposed to morality, it is void. For example, a landlord, he lets out his house on rent to B. Now B is a commercial sex worker. Even though A knew it, so in this, the object of using the property is immoral. Then there are certain agreements which are opposed to public policy. Uh, Term public policy means restriction of freedom from doing something in larger interest or good for the community. An agreement is void if law regards it as opposed to public policy, like trading with alien enemy when the war breaks out, interference with the administration of justice, like somebody goes and tells the witnesses that you become hostile or do not give the witness. Marriage brokerage agreement, that is, you want to break the marriage between the two people. Trafficking in public offices, and unfair or unreasonable dealings. Sometimes some agreements are partially illegal. Now, if it is possible to divide the legal part and the illegal part, then the legal part will be valid one. But if it is not possible to divide the two, then the entire contract is void. Like A promises to superintendent on behalf of B, who is a legal manufacturer, who is into manufacturing of Indigo. This is legal, and there is an illegal part also, that is trafficking in other articles, maybe other drugs. B promises to pay a salary of 10,000 rupees per annum. Now he has both the things, that is, a part of the business is legal and another part is illegal. Now, since he is getting the total payment, so it is not possible to separate out the legal from illegal business, and therefore the agreement becomes void. Yeah. Thanks, everybody. In case of any comments, suggestions, doubts, questions, please write down in the comments box.